Well, perhaps we have critical mass. I think it's been about 5 minutes. So last but not least, I'd like to welcome you to the fourth session of this year's Melbourne Forum, looking at the external face of constitutions, all of the discussion. So I'm Amanda Katzborough, and I'm joining you from Europe right now at a fairly ungodly hour. So excuse me for putting my video on late, but I have been listening to all the very interesting sessions that preceded this. And I think there's quite a lot of overlap, as I think we'll see in some of the issues that have been considered in the other sessions and what we will be looking at now in session 4. This session focuses on subnational engagement in international relations. So it's really looking at the ways in which subnational units are recognized in constitutions, and if at all they're given a role in international relations. We'll see quite a variety of practice when we look at these case studies, and also a lot of overlap with traditional issues that we look at in terms of federalism and some of the tensions around centralization of systems, trying to decentralize the division of powers in federal systems and how those are sort of implemented and overseen. So traditionally, we see that international affairs and treaty signing is a central competency. I think we've seen that over and over again in the sessions, and that tends to be a fairly almost a unified practice. I would say there's a small exception with Australia, which we're going to look at maybe here in terms of the states having diplomatic status in the UK forum. So that's quite interesting to look at. But for the most part, we see no real recognition of a legal personality for subnational units internationally, and that's quite common. But we also see with federalism in general a sort of recognition of the closeness or proximity of a government to the people and how that can enable understanding of local issues, which if that understanding is inserted in national level politics and debates, can lead to better policy development in theory that is more responsive to these issues. And with climate change, we've discussed at length also foreign direct investment. These new challenges and new realities of our world are requiring us to rethink the role of subnational governments in foreign relations and whether there might be a need for a more robust role. We'll look at that across these case studies, and I think all of our panelists have opinions on that, so I look forward to hearing from them around that. But I think what we also see is that whether the Constitution really speaks to a direct role for subnational units isn't what matters the most. It's really the devil in the details, as we say, and I think we've seen that also in the other panels and discussions. For example, the way that oversight might work and subnational units might be involved in oversight of treaty signing through some of the processes that we've looked at in parliaments and Congress. There's also sort of specialized bodies that have been developed. We'll look at that in Australia, particularly to sort of try to give subnational units more of a voice in foreign relations and in decisions around treaty making. And I think we see some really interesting sort of attempts to maybe distinguish between the types of treaties and areas that subnational governments might be able to be involved in. So a distinction, for example, between diplomatic agreements in the Solomons versus business arrangements, and a similar sort of a distinction in Australia, where the subnational units are allowed to sign what are called lesser, or what Georgia has referred to as lesser arrangements. So I want to look into that, but MOUs and other forms of legal agreements, but not treaties, right? So where are those distinctions being made? And as we see more and more practices in the Solomon Islands, there's also very interesting case study of a sort of sister city arrangement between municipalities. And so I think there's a lot of evolving practice around maybe not formal international relations in the classic sense that we've thought about it through treaties, but really in sort of different types of collaboration between international actors and local governments or provincial subnational governments. I think the rise of cities is also very interesting, and so looking at municipal governments alongside of the classic provincial or state governments will be quite interesting in this panel. And I think with that, I will close my introductions and turn it over to our panelists. I want to acknowledge, unfortunately, that we were supposed to also have a panelist today from India who is unwell, and we're wishing him a very speedy and safe recovery. And also sorry that that perspective will not be integrated in this panel because, of course, India is a very important example in the region. But I want to invite our other Melbourne Forum members to compensate for that, and please feel free to weigh in. I know this is a big issue in a lot of the case studies that are not formally represented on this panel, so it will be great to hear from you in that regard. As usual, the Melbourne Forum, each panelist has submitted a paper in advance. We hope that you've read them, and we'll give everyone 5 minutes, try to keep you to time, and to discuss that paper. So I'd like to start with Dipendra Jha on Nepal. Dipendra is the Chief Attorney of Province 2 in Nepal, and he's practiced law at the Supreme Court until he was appointed into this role. He has a master's degree in peace and conflict studies from Bradford University in the UK, and a second master's in human rights from Thailand. He's engaged by the first and second constituent assemblies in Nepal that were writing the new constitution as a constitutional expert, particularly advising on the issue of federalism. So it'll be very interesting to hear his opinions on this. And his book, Federal Nepal Trial and Tribulation, came out in 2018 and is an excellent read if you'd like to learn more about this case study. So with that, Dipendra, I'll turn it over to you.
Thank you, Amanda. Good morning to everyone. And I would like to wish Happy Diwali to everyone, because this is a great festival in India and Nepal. So 4th November is really important day here, and I'm happy to present on this important day. As you know, Nepal has 7 constitution in last 71 years, and this 7th constitution, which was promulgated in 2015, has new elements of federalism, basically, which is the only different component the rest of the 6 constitutions. And the new constitutional arrangement is there are 3 tiers of government, basically 753 governments at local level, 7 provincial government, and 1 federal government. And we have residual power remain with the federal governments. We have separate list for the exclusive list for division of power among 3 tiers of governments. Like in Schedule 5, there are 35 exclusive powers remain with the federal government, whereas 21 exclusive power remain with provincial government and 22 with the local governments. And we have separate act based on the constitution, which is the Intergovernmental Fiscal Arrangement Acts, section 12.4, which says that provincial government cannot directly deal with the international's donor agency, with the international government. So that's has been somehow narrowed down by the act, not by the constitution. In fact, though even in the constitution, section 5, in serial number 6, basically, it says that foreign affairs, international relation, this power remain with the federal government, basically. So in the last 3.5 years, as I'm Attorney General of the provincial government, Province 2, which is like the 2nd largest on a population basis, provincial governments. My experience, how we engage with the international relation, I'm going to share. First experience that I feel when Indian Prime Minister Narendra Modi visited Nepal in our provincial capital, Janakpur. At that time, we faced that the invitation was issued from the foreign ministry by the federal governments, and when the date was fixed, the federal government sent an officer here, and he was the one who arranged everything here, who decide the schedule, decide what type of arrangement should be here, where he should remain, who should participate in the program, who shouldn't participate in the program. So everything was decided by a protocol officer who came from Kathmandu. And then I realized at that time, basically, even I was Attorney General, but I was not allowed to enter in certain premises, in certain areas. So then I realized, really, are we government? So that type of feeling, first time I feel when Prime Minister Narendra Modi visited Nepal in 2016. Second time I encountered, actually we got an invitation, our Honorable Chief Minister and me got invitation from America, which is like a ANTA organization called. It's a people living Tarai from plain area in America. They have their organization. They invited us in their General Assembly as the chief guest, and I was invited as the special guest. Then our chief minister applied for passport and visa in foreign ministry, and at that time the foreign secretary was Shankar Das Bairagi, who is also chief secretary now, and his passport and visa request was actually rejected, denied. Then at that time I made intervention and I said that, okay, I will sue you in the court if you do not issue the red passport, basically. And we were supposed to, we have given deadline, actually just we got passport, red passport a day before the flight schedule was, basically. And at that time, how we got the passport of chief ministers, we got only when we said that we are going to call a press conference if you don't give us, and we will expose everything. Then they were forced to give us passport at that times. And finally, the last day before the schedule of flight, we got passport and we visited America. So that was the second moment I realized that, okay, this is international relation and foreign relation. We can do nothing as subnational governments. So that was the second experience I have. In terms of even in investment, I would like to share an example which happened yesterday, basically. Now the UK has a youth employment program which is called SEEP program, and they want to have an agreement with the provincial.
Note that there's time is up, but we can give you 1 or 2 more minutes. But just
Sure. Not much example. Just I would about the investment. Also, I want to give one example. So UK government, UK ad with the youth employment program want to have an agreement with the provincial government for the program. But for that, the procedure is that they have to get permission first with the foreign ministry and the federal government, and the second permission they have to get it from the finance ministry in Kathmandu. And third thing, that even we sign MOU, we have to get approval of our total fund from a section from the finance ministry, even after signing agreement with the UK. So you can understand that all our documents should be endorsed by the finance ministry. We cannot run the project directly with the international investment. And finally, definitely one more thing that I would like to air, just American ambassador is coming this week to Janakpur. Very interestingly, we have another festival called Chhat, and he is coming. So this time we are going to receive him and organize a dinner at our residence. I'm sure that he should get permission from the foreign ministry. And here in our capital, foreign ministry has sent a protocol officer here in Janakpur, and he has to be engaged at all the meetings. Without his engagement, we cannot move. So you can understand that actually there is no any space for the subnational government for any kind of activity, not only investment, even for the personal relation, individual relations, we have to get a permission from the foreign ministry in terms of international relation. So sometime I realized that subnational government has any kind of power or authority to engage at international level. Definitely in a closed door meeting, secretly, we met an ambassador in Kathmandu. We negotiate with the donors, we negotiate with the investor, but that shouldn't make public. If that would make public, that could cause a big controversy that without approval, we negotiated. And that could be big shame for the governments. And that is also called breach of the protocol, breach of the code of the conducts. So this is the experience I have in last 3.5 years. So what I feel that particularly at subnational governments, engaging with the international relation is really important, because in terms of India, what we heard, then our neighbor chief minister in Bihar, Nitish Kumar, he negotiated with the Japanese government. He negotiated and make arrangement of everything with the American governments, with other governments, in Mexican governments, and they make a deal usually, which we can't do here. So even in terms of when you compare the Nepali context of federalism in terms of international relation with India, it's really like we are in a weaker position. So thank you very much. I think I'm running out of time. I thank Amanda for reminding me about the times, and I would respond any question if you have. Thank you.
Thank you so much, Dean, for bringing in the comparative practice of India. Since we don't have our panelists, it's very helpful to have that as a talking point, and hopefully we can bring that out more in the discussion. I think that your inputs just really highlight the beauty of the Melbourne Forum and really give texture to this conversation, right? So I think, as I said, there's one thing in the law and what's actually written in the Constitution and laws and policies that interact with these areas of foreign investment, but another how the practices are carried out, and you see in the attitudes, right, of different officials and everything, where true autonomy lies. So thank you for adding that. I think we'll go next to Georgie from representing Australia. So Georgie Clough is a MPhil candidate at Melbourne Law School. Her research considers the implications of the domestic regulation of foreign affairs and allocation of foreign relation powers for public international law. She's previously worked as a commercial solicitor at an Australian law firm and brings that experience also into this discussion. Thank you for being here, Georgie, and I'll turn it over to you.
Thanks very much, Amanda, and thanks, Dipendra, for that. It was really interesting to hear the Nepalese perspective, which is quite different, I think, to the Australian experience in many respects. In the time I have, I thought I might focus in particular on one piece of legislation that's been introduced just in the last 12 months in Australia, and that quite drastically alters the ability of subnational governments to conduct international relations. The very short version of the constitutional background to the legislation is that the Constitution doesn't expressly permit or prohibit subnational international activity. It doesn't really say all that much at all about the conduct of Australia's external affairs, because at the time it was written, Australia wasn't an independent nation and wasn't expected to be conducting its own international relations, but that has obviously now changed. And it's accepted that only the Commonwealth government, the federal government, has international legal personality and can enter into treaties and conduct formal diplomatic relations on behalf of Australia, with the quirk that you mentioned, Amanda, of the sort of limited diplomatic consular privileges that were preserved in the United Kingdom for some time for state governments. But beyond those specific constitutional powers, the precise outer limits of the ability of subnational governments to conduct international relations of their own have never been sort of properly identified, and in practice, state governments in particular and territory governments as well have long-standing practices of entering into relations with other governments and representing their interests overseas, particularly their economic interests. And they've done so without any specific requirement for approval or oversight from the Commonwealth government. But that has now changed with the introduction of this legislation called the Australia's Foreign Relations Act, which came into effect in December of last year. And the Act creates a scheme under which Australian state, territory and local governments must notify the Commonwealth Minister for Foreign Affairs before they enter into, and in certain circumstances before they commence negotiating, a written arrangement with a foreign national or subnational government. And the arrangement doesn't have to be legally binding. The only requirement is that it be written, so it applies to memoranda of understanding, as a vague agreement to cooperate on something or other. And once the minister has been notified of the arrangement, they are required to either approve it before it can go ahead, or they have the power to prohibit it, depending on the type of arrangement. And the minister has an additional power under the legislation to declare arrangements that are already in effect, of which there are many thousand, to be invalid. The test that the minister is to apply in assessing each of the arrangements under the Act asks whether the arrangement would be inconsistent with Australia's foreign policy or would undermine Australia's foreign relations. There's very little guidance provided, formal guidance provided in the legislation about the definition of those terms or the application of the test. DFAT, the Department of Foreign Affairs, has established a task force to work on this, to administer this legislation. So over time, some sort of practice might emerge, but at this stage, it's still unclear what that will look like. I should say as well that, as an aside, this legislation also applies to arrangements between Australian universities and some foreign governments and foreign universities, which raises a whole set of other issues that I won't go into now. But in closing, I think I would just say that this legislation, which constitutes quite a marked departure from over a century of practice of state and territory international engagement, should be understood, I think, in the context of several political and geopolitical factors that have quite heavily influenced its introduction. It's, on one view, the series it is the latest in a series of measures taken to address concerns about foreign interference in Australia, taken in the last few years, particularly foreign interference by China, even though the legislation is, doesn't say it, and the government is adamant that it is country agnostic. But I think it was generally accepted before the legislation was introduced that it had as well at least a target to memoranda of understanding between the Victorian state government and the Chinese government about the Belt and Road Initiative, which the Commonwealth government had been openly opposed to for some time, and which were declared invalid under the Act in April of this year. So I'll leave it at that, but looking forward to further discussion.
Thank you so much, Fergie. And I was struck that, I know you mentioned that the test is not well defined in the terms within the test, but, in comparison to the Nepal case, for example, where the minister has also the ability to interfere clearly, as Dipendra said, but there isn't a test, right? We really say when the minister says yes or no. And I think it's, at least the test gives you something to go on and improve. But also interesting to see how the relations in Australia have changed over time. And I think, you have much more time as a federation to see how these things have evolved, whereas Nepal, of course, a relatively new federal system. So maybe learning some of these practices, but I think the institutional innovations in Australia are also interesting. The Treaty Council and other things, which maybe we can discuss later. So without further ado, I'll go to our last panelist on this session. Dr. Joseph Fukona, and I'm trying to see you in the video, is an assistant professor in the history department at the University of Hawaii. He's a Pacific law and history scholar with a strong university and professional teaching practice, mentoring, and research record. He has a PhD from Australian National University and previously taught at the University of the South Pacific as a senior lecturer. We're very happy to have him here today representing the interesting case of the Solomon Islands. So with that, I'll turn it over to you, Joseph.
Okay. Thanks for having me, and thanks for such a very informative discussion so far as well. I'll just share my screen. I have four slides, so I'll try and make 1 minute per slide. Can you see my slide? Can you see the slide?
Yes, we're seeing
okay.
the slide. Thank you.
All right. So the Solomon Islands was a British protectorate from 1893 to 1978, when it became an independent state, and it inherited a unitary system of parliamentary democracy from Great Britain. And initially, after independence, there were 3 levels of government. So one level was the national level, the other level was the provincial level, and then we have a third one, which is known as area councils. But from 1997, the area councils were abolished, so now we only have 2 levels of government: the national level and the provincial level. Now, in terms of the structure, at the national level, we have 50 members of parliament, and we have an executive government, which is made up of 20 ministries, but the law allows that the ministries can be increased up to 23. So far we have 20 government ministries, so which means that there are 20 20 ministers. Now, at the subnational level, there are 9 provinces, as you can see on the slide here, with 9 assemblies, 9 provincial assemblies, and the Honiara City Council. So those are the subnational national units. And the provinces have elected members from different wards who make up the provincial assembly. And the provincial administration is responsible for implementing various government services at the provincial level. Now, in terms of a legal framework, there are three laws that come into play in terms of the operation of the national government and the provincial government, and these also govern the way in which there's interaction, not only at the domestic level but also at the international level. So the Constitution provides sort of a general framework for the existence of provinces, as well as the Honiara City Council, and these, because of the way in which the law is framed, these subnational governments do not have a international legal personality. So under the legislative framework, it prohibits subnational units or governments to engage in establishing, diplomatic relations or relations of a diplomatic nature with any foreign country. But the law allows subnational units or provincial governments to establish any relationship that is of an economic or development nature, but with the consent of the minister. And this is where it can be tricky, and this is where there could be it could subject to also political interference as well. So because of the way in which the law regulates the way in which the provincial and the national government interact, how subnational units are organized and structured are really symmetrical, but in practice, they are asymmetric because of differences in capacity across different provinces. And also the other point to note also is, while provinces are given certain kinds of powers to operate at the subnational level, the overall power remains with the executive government. Now there are examples of subnational units or provinces entering into relationships of a business or diplomatic nature with foreign countries, and these are usually done under bilateral agreement that the country has with foreign countries or foreign powers. But this is usually a challenge when it comes to follow up on the agreements, due to lack of political will and also political differences between actors at the national level and the provincial level. Now moving on to my next slide. So this slide just shows you that the light green areas are all customary land areas, and the shaded orange color really where you have title land. So you can see that the subnational units or governments are much more closer to the resource owners than the national, the national government or the executive government. But in terms of how the law is structures the relationship between national and subnational, more powers vested in the national government or the executive government. But when it comes to issues of, resource access, the national government would have to negotiate with landowners, and this is where the role of subnational governments becomes important. And
so note that we're over time. Again, it's fine. Please.
Okay. So
finish,
yeah. So
but, don't feel like you have to finish now, but just to let you know we are.
yeah. So my last point is the way in which the national and the subnational is structured. There is a very high centralized focus in terms of development, and over the years there has been push for reform, for decentralization and change in terms of the structure, and there's a push for federal system of government. Okay, thank you. I'll stop here.
Thank you so much, and also for the slides. It's incredibly useful to have the visualization. I think really enriches the discussion. I was struck actually in your paper by this idea of de facto asymmetry, even though it's a symmetrical system in theory. And I think that was also raised in Dipendra's paper about the fact that actually it is a symmetric federal system in Nepal, but different provinces have different resources and also very different populations, and that leads in practice to asymmetry, even though that's not formally what's written down. So thank you so much. Since we unfortunately don't have our fourth panelist, that concludes the formal case studies that we were to look at as part of this panel. I think there's a lot of interesting things to discuss, so I do want to open it up. But before doing that, I wasn't sure on this last point of asymmetry, if anyone from the Philippines or Indonesia, PNG with Chris, wants to comment on international relations in sort of formally asymmetric systems, if there's anything interesting to note about the subnational units in those places having different roles in international relations. But if not, I will just open the floor to more general comments. Yes, Alim, yes, that would be great if you feel comfortable to speak a little maybe about BARM and how that's been envisioned.
Yeah, Dean Benny actually informed me that he will be on flight. So yes, the BARM or the Bangsamoro Organic Law is one of the statutes that we really give value in terms of engaging the role of the indigenous community and the recognition of the rights of the Bangsamoro people. I used to serve the Bangsamoro before we changed the administration. I used to be the executive director of the Regional Economic Zone Authority. And yes, true to what the law give priority with is in terms of the investments. We don't, we at the national government, we don't interfere on that. So they have their own Ministry of Trade, and that is very specific into the Bangsamoro Organic Law. Also in terms of the conduct of trade and international relations, they have the legitimacy to generate their own investment. So as far as the law is concerned, there are also some national laws that I mentioned earlier. For example, the Republic Act 11439, the support the inclusive economic policy of the Bangsamoro, the creation of the Sharia Bank within the Philippines, as well as their participation in the halal trade, local and international. So I hope that would be a recent update. And in terms of the respect to the autonomy, we recently signed. There is a recent involvement of the president in terms of the executive body to extend normally there's supposed to be an election, but because we understood that 3 years is not enough to for the local government to prepare, not only with domestic policies, not only with economic policies, but also with participative election, we extended the election for the local government. So they will still enjoy another 3 years to exercise all the privileges and rights given to a local Bangsamoro government. Thank you, Amanda.
Thank you so much, Ellen. Chris, would you like to comment on this in relation to PNG? I think you actually made some relevant comments already in your formal.
Okay. Amanda, can you hear me? Hello? Okay. Thank you for that. I think I would agree with Joseph. We have a similar subnational government here in PNG where the national government as the foreign affairs relations, that's more centralized. We do have a provincial government and we call it the local level government. That's the third tier government we have in PNG. Now, what we, the provincial governments and local level government, they don't have the power to directly enter into any relation with the international, the organizations or even governments or states. So they seek approval from the national government to enter into such relations. And I think that's the same story here as well as in other Pacific Island countries, I guess. Thank you.
Thank you so much. Unless anyone else wants to make a sort of insertion on behalf of your country, I see questions, so I will perhaps turn it over. Lena first, and then Anna, and then Cheryl. Maybe you can take those, assuming the questions aren't too long, 3 questions, and then open for another round after that. Lena, do you want to start?
Yeah. All right. Yeah. Thank you. Thank you, everyone. My first question is to Dipendra. Understanding that current constitution does not provide any role for the states in dealing with the world, and that federalization has only recently begun, and much of the basics are under construction, and very sort of a rigid, centralized mindset probably very much prevails. But how do you see the future of states in this regard? Do you think there is a desire to negotiate that space, even towards something that what Georgie talked about, where states can anyhow initiate some of the arrangements for federal consideration, or do the states care? I kind of got the impression that you're not entirely happy with the situation as it is at the moment in Nepal. And another aspect to anyone is really the question of whether the states have any role in formulating foreign policies or the foreign policy. I'm asking this as I know that Habimon Jacob, who unfortunately couldn't attend today, he has been writing about this in the Indian context, where apparently Prime Minister Modi has realized the necessity of getting the countries, these regional governments on board on what it comes to foreign policy endeavors on some aspects, even though, as I understand, the actual success has been somewhat limited, but at least some discussion towards such arrangement has begun. If anyone else have any views or experience of such. Thank you.
Thank you, Lena. I've taken note of the questions, but I hope the panelists have too. And with maybe Anna, if you also want to ask your question.
So my question is actually Lena's second question. So she took it from me. But I was really interested in this idea that we've heard from, I think, Solomons and Nepal in particular, that you need the permission and consent of the central government if a province, for example, is to engage in any kind of international agreement making or relationships. And I did wonder, like Lena, about is there anything that happens the other way around? And I think this could be particularly important, for example, in relation to international aid, which might be directed to education or health or things that are more of a provincial government issue, and how the province that gets the aid eventually has any say in negotiating those relationships with foreign states in that context. So that was my question. Thank you so much.
Thank you, Anna. Cheryl, I think we can fit your question as well before. You're on mute, unfortunately.
So I have a reflection, and it really picks up on what both Lena and Anna said. But I was just thinking as I was listening to the panelists, 20 years ago or more, or maybe a bit more, the whole question of the role of subnational institutions in international affairs was a hot question. And it was a hot question because national governments were entering into more and more treaties that was eating into the power of subnational units, and the issue arose whether subnational units should participate in making foreign policy decisions. And Australia did put in place a system for that, and I won't go into that because Georgie may want to talk about it. And it's interesting that that happened then, and then that died down. I think in various parts of the world, those processes have been quite richly developed. I mean, in Germany, for example, the way in which subnational participation in international arrangements goes on is really very sophisticated and also elsewhere. But it's interesting to me that we've now swung to this dimension where now we're much more talking about the extent to which subnational units can go at themselves in all sorts of contexts, one being aid, which Anna mentioned, but the other being reactions to climate change, which is a big issue. And to see national governments pushing back against this. I mean, the defensiveness on the part of national governments at this point makes you think, what on earth is going on that's making them do that? I mean, is it the geopolitical situation? Maybe to some extent. Is it that they're feeling threatened in some other way? So it's a very interesting continuum of interest in these issues, but taking different form at different points in time. So I'm also, just to put the question, very interested in the answer to the same question that Lena and Anna have both put. To what extent do subnational institutions participate at the national level in making international policy?
Thank you so much, Cheryl. I think I'll turn it over to the panelists with that. Just to comment, I was struck in Georgie's paper when she mentioned that there's this new move in Australia, the rhetoric around having a unified foreign policy, and what you just said about defensiveness, I think, is quite interesting to think in the context of geopolitics today, where this is coming from. So maybe depending on quite a specific question to you from Lena, so we could maybe start there, and then if anyone else wants to weigh in on the more general theme of how subnational units maybe participate in formulating foreign policy, if not in entering direct agreements.
Thank you, Amanda. Thank you for three questions. Lena, I would like to address first the Lena question. Definitely, I see future is like a hopeful future in a way that we're trying to make a space within the narrow structures. And there is a desire, in fact, in all leaderships. Lumini province chief minister, who is very earlier close to the prime minister from the same party, he made a direct agreement with I think 2 governments and said that we could negotiate, we can make all the deal. It's just a formality that after making all the deals, all the arrangement, we will send a letter to get consent. So that's all the role the federal government should limit in. So it was a public statement in a television interview by one of the chief minister who at that time was close to the prime ministers. So you can understand that there is a strong desire to widen the space for engaging at international level. Similarly, Province 1, basically, it has not named yet, made an agreement with the Swiss governments, and they have made all the deals. They have negotiated everything. Only the finance minister at that time from the federal government was invited in the ceremony. So you can, these 2 examples set can answers. Definitely, there is a strong desire among the leadership at subnational level to widen the space, basically, and find ways how to widen the narrow legal provision and constitutional provision through the practice, in my opinion. Similarly, at the second question from Anna, basically about the international aid, I would like to share one examples. During the COVID pandemic, I got there was a tweet by the UK ambassador in a Twitter that big ad medical equipments are coming to province to make sure that you get it properly. And then I checked with the health department, our health ministry, and we found that it has not been received. Then I responded on Twitter that though you have sent to us, we have not received it. Please check where is the fault. And then she checked the fault, and they found that they kept everything in their storage in Kathmandu, and they wanted to send to other provinces or other places. So about that, you can see that when someone approached to Kathmandu, basically at federal government, where do you want to go? They will say, no, don't go to province 2, go to the other provinces with other places. So these dynamics we face actually usually. So that I would like to. And third question, then Cheryl asked about what our role in formulating the foreign policy. Basically, we are not being consulted, we are not being asked, we are not being like, there is no any draft sent to us for getting any feedback, basically. So they make it by themselves, but definitely when we hear like they make a policy on the foreign investment, and there we found that they have a strong clause that subnational government cannot negotiate. When we got that paper, we objected, and we have written later that this clause should be amended because it's against the spirit of federalism. And then we got a response at that time. So basically, through formal channel, there is no engagement in making foreign policy. But definitely, when we get complaint, we at that time we intervene. Thank you.
Thank you so much. Joseph and Georgie, would you like to?
Just responding to the question on subnational engagement in terms of foreign policy. The straightforward answer is there's really no consultation by the national government with provincial governments when it comes to formulation of or design of foreign policy. And a classic example is the recent switch by the Solomons to China, switch from Taiwan to China. That came after the 2019 elections. Now, during that election, no politician actually campaigned on sort of, to engage public discussion around some of these policy issues or international policy issues. It's also because of the perception that subnational units are just agents of the national government, so they have to listen to what the national government says. So that's the general perception. Although in law it doesn't operate that way, as to strictly following the principal agent arrangement. But that's the general perception by national bureaucrats as well as politicians, that subnational units are just agents of the national government. So they are expected to follow whatever decision or policy that the national government comes up with. So if a subnational unit disagrees along policy lines, that's usually perceived as you're going against the national government. And partly also because it's because of national politicians, they're also threatened as well, because in every 4 years, after every 4 years, you have an election, and if you have actors that are very popular at the subnational level, there's a high chance that they could be elected. So there's also politics as well around this interaction at the national and in the provincial.
And on a slightly separate note, I did know, Anna, you said this idea of, is the relationship ever reversed where the sort of provincial government's taking the lead? And I think, Joseph, your paper brought up a really interesting point of ownership, and that when the provinces sort of have taken the lead on these sorts of agreements, that there's been sort of a problem of having the central government come on board with the will to implement them. And I thought that was an interesting consideration, because often we might push for more role for the subnational governments, but we can't forget that having buy-in from the central government is also important. So, yeah. Georgie, do you want to? Oh, sorry. Go ahead.
Yeah, and just by observation, you hardly see any of the premiers at the subnational level engage in international forums. About climate change or about other issues. Although they are the actors that are much more closer to the people on the ground.
Thank you. Is that also true for economic forums? I'm just wondering, because you did make the distinction of, are there subnational governments participating in international forums on economic issues, or is that also limited?
Yeah, economic climate change. But there's this, there's slightly changes in terms of approach by donors or bilateral partners going into the country and visiting sort of the subnational and engaging in discussions and dialogue with the subnational actors. So there's a shift in terms of approach by international actors, going in and actually meeting with people who play an influential role at the subnational level.
Thank you so much. Georgie, I'd love to hear your thoughts on this too. Australia did have a formal mechanism, as Cheryl mentioned, for getting inputs from the subnational government, but has now, as you've said in your remarks, sort of moved back maybe towards a more centralized system. So it would be interesting to hear how that evolution has occurred.
Yeah, so subnational governments in Australia don't play a formal role in the development of Australia's foreign policy. That's very much a prerogative of the national government, and I don't think one on which subnational governments often express much interest, sort of generally. But there are processes established some decades ago for consultation between the national government and state and territory governments on treaty on the assumption of international obligations and proposed treaties, and I'll pick up on Cheryl's point as well about the timing of those reforms. And I guess there is also a sense in which subnational governments play a role in foreign policy, because the nature of the federal division of legislative responsibilities in Australia is such that, at least in the past, the national government has had to depend somewhat on the state governments to implement Australia's international obligations. That's not the case anymore, but even after that's changed, state governments and the national government have adopted often a sort of cooperative approach to the implementation of Australia's international obligations. So I guess that's another respect in which they play a role in Australia's foreign policy. But I think the point that Cheryl makes is obviously very relevant in the Australian context, that in the sort of 70s and 80s, there were a series of High Court decisions that drastically expanded the power of the national government to implement Australia's international obligations, which also expanded its power to assume them, free of any sort of need to get the state's permission first. And that led to these concerns that, as a result, the states weren't going to have a say anymore in the national government's foreign activities, and it would be able to assume all sorts of international obligations that would affect them, which led to this series of reforms that were meant to ensure a place for the states in consultation prior to entering into treaties. There were further reforms in the 90s. But I think that the focus on those has really dropped away ever since. I read recently there was a parliamentary committee report in the 90s that sort of really picked up on this issue, recommended the establishment of what's called a Treaties Council, which was subsequently established. It met once the following year and hasn't met since. And then afterwards I read the report of a parliamentary committee on the treaty making process written 20 years later that spent a couple of pages discussing the process for consultation with states and territories, and then noted that it hadn't really received many submissions from the state and territory governments on the point, not enough to really form a view, and moved on to something else. And my sense is really that this issue did reach its zenith in the maybe 20 or 30 years ago in Australia, and I'm struggling to find evidence at the moment of the same kind of issues still being live. And now, as Cheryl said, it's very much the reverse issue of the national government being quite insular and sort of trying to limit international openness by subnational governments.
Thank you so much for Cheryl. Yes, did you want to respond to that?
Yeah, thanks, Georgie. That was really interesting, and I'm sure that what your researchers have uncovered is right. But I was just thinking as you were speaking, I wonder if that's because treaty making itself has died down a bit, as far as being a sort of a high-profile foreign policy issues concerned, and foreign policy is now going down other tracks, like sort of going to Glasgow and making or not making commitments about climate change. And in relation to something like that, I mean, the states can play foreign policy just like anybody else can play foreign policy. And so we have the situation in Australia where the Commonwealth government is cautious in doing anything about climate change, to put it mildly. And the states themselves have overt policies, which they trumpet perfectly heavily to try to bring down emissions, and in fact are widely credited with whatever gains Australia's managed to take. So that's sort of, I was talking earlier about foreign policy. Obviously that was loose talk on my part. The intergovernmental arrangements are only directed at treaty making ultimately. But because international relations infiltrate so much of what governments do these days, it can play out in all sorts of ways in a system of multi-level government, which is interesting to watch.
Which, if I can just respond, I think is what is so interesting about this new piece of legislation, because it's been couched very much in terms of national security and protecting Australia's national interests, which are very much, according to this legislation, it's national security interests, with very little consideration of how it might stymie all sorts of other activities that are relevant to Australia's to foreign policy or international law or all sorts of international issues. And I think that at least the way that the legislation was debated and the way it's been discussed shows a sort of lack of understanding of how those two, or maybe there is an understanding and it's what is intended, but I think that the way in which foreign policy and engagement with international issues has changed means that something like this has the potential to affect activity that might really have implications for the way that Australia engages with the rest of the world. Even though it's, the legislation on page 1 makes it of the explanatory memorandum makes an explicit distinction between international treaties, which are the domain of the Commonwealth, and all of these other arrangements that state and territory governments go off and enter into. And I'm not sure that the distinction can anymore be so easily maintained, but.
Yeah.
Really interesting. Thank you. Fiona, I see your hand. If you'd like to weigh in here.
Hi, thanks. So I had a question about, we've talked a lot about subnational government expectations or desires, I suppose, to get involved in foreign policy or engage in international relations. But I was wondering about what the expectations of the constituents of those regions might be to have their subnational governments engage in international relations. So Cheryl mentioned the states are working really hard in Australia to address climate change, where the federal government isn't doing that. So I guess just across all of the jurisdictions, is there a demand amongst constituents for this kind of activity, and is it expected of their subnational governments to actually carry out this work, or is it largely a demand on the federal government?
Thank you so much. Excellent question, and also very relevant to the prior discussion. Aleem, I see your hand up as well. Would you like to ask your question before we turn to the panelists?
Thank you very much, Amanda. What is common also from the presentation from the panelists, like what has been highlighted in the presentation of Australia, that the Commonwealth Constitution does not expressly provide for or prohibit the involvement of subnational government. And I think also common to the other presenters, they made mention that there's no express power for the subnational government. How are these being remedied in terms of providing participation to the subnational government to make sure that they would also have a say to the treaties that are being ratified but not by the federal government or the national government? Are there any steps of action from the panelists in your experience, in your country's experience, to make sure that these are being remedied, not only through constitutional remedy, but also in terms of lobbying? Is there a particular experience that you can cite in terms of providing remedy to this? Thank you.
Thank you so much. Does anyone want to take those questions, or?
I'll go first. I'll take Fiona's question. So appetite at the subnational level by constituents. Currently in the Solomons, there is the US aid have announced a $25 million aid support to Malaita province. So that's an example of aid that flows directly through to a subnational unit. And they do it through international NGOs that were incorporated locally. There's popular support by people at the subnational level in terms of seeing that there's actually a change in terms of the approach by seeing the subnational government actually. There is some link with sort of outside development assistance. There are, because of visibility, there is support, and people, I guess people, it also plays out into the geopolitics, around China and also US as well. Now, in terms of remedies, what's happening for the case of the Solomons? There are some, at the subnational level, they sort of, governments try to work on improving their local ordinances to address issues around climate change, but capturing sort of the international frames. So, instance for Malaita province, they've announced as part of their policy, a climate emergency, so linking to sort of international discussions. So there's sort of subnational units are trying to come up with ways in which they can, within the limits of the law, to improve things at the subnational level in terms of business licenses, local level of the ordinances, and trying to invite more dialogue and discussion with national level actors. But in terms of changing the law at the national level, that really depends on the national level politicians. Yeah.
Thank you. Yes, Dipendra, please.
Can I just add to the point Joseph mentioned?
Yes, please do, please.
Yeah, I would like to respond to Fiona question about the constraint, basically. Just like the example that I shared during my presentation, when Indian Prime Minister came here, he announced 10 million Indian currency as a aid to the provincial government, basically, for the purpose of making Ramayana circuit. It's a road, a religious road, basically from India to Nepal. And since last 2 years, we have been trying to get that fund from India to construct the Ramayana circuit, basically. But unfortunately, the Prime Minister objected at that time. The Indian Prime Minister visited to provincial capital, and how can he announce 10 million aid to the provincial government without our consent? So I'm not agreed, and we cannot facilitate to get that money. And since last 2 years, we are getting huge pressure from constraint from larger public that why are you not being able to take that money and construct that road? So we are under a huge pressure from the public, and they want that money to come here, basically. So definitely there is a popular expectation, support from constituency, basically to engage at international level in terms of development, basically, in terms of the relation we have, like economic, cultural relation that we have. And there is another road called Hulaki Road. It's a big road in India-Nepal border lines. And people are now asking the question to the provincial governments, why this road has not been constructed. They know the limitation, but their expectation is that this area has to be expanded so that the subnational government could help to construct the road, basically. So definitely there is a craze, basically, to expand the narrow jurisdiction that to engage international level. Thank you.
Thank you so much, Dipendra. Georgie, would you like to respond to this question?
Yeah, maybe if I could just comment quickly on the question of sort of popular expectations of subnational governments. I've been wondering about this a little, I think, particularly because I have a sense, at least in Australia at the moment, that popular understandings of the Federation generally might be shifting a little in light of COVID and the COVID response. And I don't know if that will affect anything, but my feelings, which aren't really based on all that much, but my sense is that constituents of subnational governments in Australia haven't really had much of an expectation that state and territory governments should be playing a foreign policy role. I think that role is generally understood to be a role of the national government. But I do also think that in the last 18 months or 2 years in Australia, as we've had this very much subnational government-led pandemic response, where I think a whole lot of Australians have realised for the first time exactly how, at least constitutionally powerful, state and territory governments still are, and where a lot of state premiers and territory chief ministers have become incredibly popular and obtained this kind of level of relevance that I don't think they've had for some time. I feel like people are perhaps starting to identify a little more with their local jurisdiction and expect perhaps that those levels of government might be able to provide effective governance solutions. And I do think I'm not sure if climate is just a kind of sui generis thing, because I think people in Australia are just generally keen for anyone to do something about climate, given that our national government is proving not really up to the task at the moment. But I do wonder if there might be a growing expectation from constituents that subnational governments in Australia might be looking for a role, or might be in a position to take a role on international issues more so than there has been in the past.
Mm.
Thank you so much, Georgie. I wonder also, you know, you're speaking like Australian citizens as a whole maybe care about climate change. I'm wondering if in certain countries where, you know, there's areas that are more vulnerable to climate change than others, and they might feel that it's a much more urgent concern. And I'm also thinking my own country in the United States, when you were speaking about COVID responses, and I wonder when the subnational governments' interests collide with each other, how that might be resolved, because you might have one, you know, subnational government constituency that is very progressive and one that's less progressive. And if they, you know, have different opinions on treaties, it would be interesting to know how that plays out as well. And I think you said you had a question. I don't know if anyone else, otherwise, oh, Tom, also maybe Tom first, because you haven't asked yet, and then we'll turn to Anna.
Thanks, Amanda. Yeah, I was just thinking while everybody was talking, it was really interesting to hear the view from the inside, but I'm thinking about the view from the outside too. And in many ways, I was very struck by Dipendra's paper because it seemed to present a somewhat sort of counterpoint to Shamshad's paper in session 1, where you get this process where there's a preference from the international community to have a strong president, for example, so that you have a clear, central, powerful interlocutor who you can do business with. And then I read Dipendra's paper, and you know, you get this process where you have the likes of China and Japan and Korea and the EU and so on trying to deal directly with subnational governments, and that's very different. But what I was wondering about was, can we explain them by the same process of it's kind of whatever it takes from the outside? So there's an impatience with the domestic structures and domestic processes. It's just, let's get it done. So, or are they both possibly, and I'm just throwing this out for everyone, are they both possibly pretty unusual situations where you have a high level of international involvement with the constitution making process itself? And so, you know, in Afghanistan, it's about, we wanted that strong leader, so that's who we're going to deal with. In Nepal, we supported a federal structure, so this seems appropriate. And the very final sort of question I would just put out there is, you know, from the outside once again, is behind some of this an unhelpful starting background assumption that we can still make a clear distinction between the more political involvement and the more technical involvement? You know, political being clearly the stuff that really is at the heart of foreign relations and how power works, but the technical being building roads, building hospitals, giving foreign aid. Just 3 things that really occurred to me about the view from the outside. I'd be really interested in your views, Dipendra especially, but everyone.
Thank you so much, Tom. As you know, we often close the Melbourne Forum with a reflection on international assistance and how it kind of interacts with the theme that we're looking at. So I think it's good that you've brought this up, even though that wasn't structurally part of the panel this year. Anna, do you want to ask one question before we turn to the panel?
Yeah, sure. It kind of, like Tom, but slightly differently, brings back the constitution building aspect of some of this. And I was really interested to ask Joseph about the ongoing constitution making process in Solomon Islands, where a federal constitution has been talked about for many years now. And I was interested when Joseph described the relationship between the centre and the subnational units as sort of, you know, the agents of the centre. And I wondered how, if you think that that's going to change if and when a federal constitution is put into place, and whether the issues around Malaita, the shift to China, climate change, and, you know, provinces trying to be a little bit more active in these spaces will somehow be reflected in what ends up in that federal constitution. So sorry, I'm asking you to look into the future. You may not be able to answer that, but I'd be really interested in your thoughts on how that might play out as the federal constitution making process evolves. Thanks so much.
Amanda, can I add a question to that before you throw it to the panel? Do you mind?
No, of course
not. So this question is to Dipendra and Joseph too. And it's a question about aid and how constitutions deal with international aid. So international aid's come in here as a really interesting example of an international arrangement, potentially either with the subnational government or designed for the benefit of the subnational government. And I think that's been a very interesting dimension of the discussion. But I've wondered more generally about whether constitutions should say anything about international aid. In a sense, international aid is a source of funds for the government, and constitutions do a lot to control all other sources of funds. It talks about how they're raised, talks about how they're distributed. Should aid be part of that story, either by going into some sort of consolidated pot, or alternatively guaranteeing some sort of fairness in the way in which it's distributed, or fidelity to the donor? I mean, there's all sorts of different principles that might be on track, but I just wondered if either of you have any thoughts about constitutions and foreign aid, whether the two should ever be mixed. Thank you.
Thank you, Cheryl. I'll turn it over then. Dipendra, do you want to start? And then we can go to Joseph.
Yeah, thank you. Thank you very much. First, I would like to address Tom's question. Definitely, there is impatience at both levels, not only at subnational level, but also at international level. And the reason behind impatience is that when they make a deal at the federal level, that is to come to the subnational level, it's a long process, time-taking process, bureaucratic hurdles, corruptions. So they want to avoid all these things basically, to deal directly. So that is the reason of impatience. I found it at international level. And there is another reason add to the reason of impatience at international level is that because at bureaucratic level there are some biasness, regional biasness, political biasness, and even the leaderships, political leaderships at the federal level, they try to prioritize international aid and development fund to their constituency, to their area particularly. Whereas the international community look at the Human Development Index, literacy rate, and they have priority something else. So this is the reason they want to deal directly with the subnational governments. And even the subnational government has impatience in a way that their priority are totally different from what the federal government think the priorities are. So sometimes like they make a policy at the central capital, but that policy does not fit in a specific context. So that's, I think, impatience I found at both levels, in my opinion, to deal directly. And that's why the narrow space of engaging at international level has been gradually being like widened, because I hear when our finance ministry made a foreign aid policy, at that time all the diplomatic agencies were invited, and they put this conditionality that if we invest, we should be allowed to deal with the subnational government directly. If you don't allow us to engage, we are not going to fund. So those kind of some of the, even I remember once I meet a Swiss ambassador. At that time, she told me that, okay, look, some of the roads we are supporting, road construction project we are supporting, it should be constructed from subnational governments, but the federal government want is to construct themselves, which I don't think is relevant, because it's a local level road and that has to be dealt by the subnational government in cooperation of local government. So you should raise this point at the political level, and I passed this message to our chief minister, and he raised this concern in the Interstate Council, which is chaired by prime ministers, and after that, this time the new finance ministers changed the policy, and now those roads are going to be constructed. The offices are closed now. The road construction federal government office at provincial level closed now, and they are going to hand over those roads to our infrastructure ministry. So sometime even like impatience, the reason of impatience, and actually I love that impatience basically, which help us a lot. Thank you very much.
Excellent. Joseph, would you?
Okay,
Sorry, you're on mute.
so I'll answer Terry's question first, and then I'll answer Anna's question. Now, under the country's constitution, there's provision for consolidated fund or special fund. So if any money that comes in for purposes of government, it goes into this special fund or consolidated fund. And provinces or subnational units are prohibited from seeking or obtaining, financial funds from international donors. So what happens is usually, for instance, the case of Malaita province, the USAID channels the fund through 5 international established NGOs. They have local incorporated bodies, and the funding goes through these NGOs for purposes mainly of in terms of infrastructure development, capacity building, assisting with improving regulations. But the province does not directly receive the funding, because that's not allowed under the sort of the existing framework to receive direct funding, and that's there's contention around this aid support by the national government. Now, in terms of the federal constitution, that's a discussion that has been going on since 2004, and I think so far there have been 4 drafts of the federal constitution, and it's the most recent draft has not been tabled in Parliament, but the draft federal constitution addresses a lot of issues around resource devolution of powers, the governance arrangements at the subnational level. So I guess if this goes through in terms of a federal structure, there might be a change in terms of the existing arrangement we have now, but there will also be huge costs involved as well in terms of moving from a provincial sort of government system to a federal system of government. So it sort of comes back to Tom's point around the support that subnational units get from international actors are really technical support, not financial.
Thank you so much. Actually, we just wanted to follow up on that with a question, if there's not another one from the crowd, and then we might close with this. I was curious in reading all of the responses from the 3 panelists that are here, that you all said that subnational governments don't have a legal personality when it comes to international relations, for sure. But we are hearing now about, and Georgia, your paper also spoke about these sort of lesser arrangements that I mentioned in the introduction, MOUs. And I'm just curious at what stage we maybe consider those to give a subnational unit some kind of legal personality. And Cheryl, you mentioned on Tuesday, I think this that now treaties are being signed, or this idea of treaty signing for Aboriginal and Indigenous groups in Australia is really between them and the subnational government. So does that give the subnational government in some way, at least they're signing treaties, they're signing contracts, maybe not internationally, but I'm wondering at what point that changes our understanding of their legal personality. And if anyone has a comment on that, and maybe after that, we'll move to the closing session.
Yeah, I mean, for the case of the Solomons, what's usually signed by subnational units or governments is usually MOUs, memorandum of understanding, kind of agreements, not treaty, treaty agreements. Yeah.
Anyone else?
Just wondered whether we could bring Georgie in on that. So the
Yeah.
Australian legislation would covers MOUs and all those forms of any sort of arrangement, don't they? Doesn't it, Georgie?
Yeah, it does. It covers anything written, whether or not legally binding. And for, one of the requirements under the legislation is that there's maintained a public register of all of the arrangements that are notified. So I've had a look through that, and all sorts of MOUs and strategic partnerships and statements of intention to cooperate on all sorts of things. In terms of the question about at what point might subnational governments be said to have attained some element of legal personality, I mean, I'm not really sure the answer to that. I guess from the perspective of international law, it would be fairly heavily contested that that at least subnational governments in Australia, based on their the constitutional allocation of powers and their activities, were at that point. And I don't think state or territory governments themselves in Australia would make that claim. I know that one has in the past, quite a long time ago, about pre-colonial status, but I don't think that's a claim that would be made anymore. But I don't necessarily think it's one that they would see as necessary to exert their international influence. I don't think a technical question of legal personality is necessarily determinative. I mean, one example that I find quite interesting are these, again, coming back to the climate example, these various agreements, they usually an MOU form between all sorts of subnational governments globally, like tens or dozens or hundreds of subnational governments, to which Australian states and territories and local governments are signatories, that all sort of state intention to achieve the goals of the Paris Agreement and are quite detailed in part about how they intend to do that. And they're not treaties, and I don't think anyone would regard them as such, but they're still quite powerful international instruments that play a role in influencing national governments, that allow for information sharing and cooperation between subnational governments. And I think a sort of emblematic of all of the various other ways that subnational governments can influence international affairs, even whether or not they're able to be considered international legal persons. But yeah.
Thank you, Georgie. Alim, I see your hand up, and I also see that we're getting several excuses and goodbyes in the chat. So maybe just to formally thank Dipendra and Vanessa, I think has already left, but for your contributions. And we will be sad to lose you for the closing ceremony, but appreciate your input so far. Alim and Miriam, and then after that, we'll turn to the closing.
Yeah, thank you, Amanda. Very quickly, for as a rejoinder to what Joseph mentioned earlier, that MOU also plays a critical role. So with my experience working in the local government in the Bangsamoro, we remedied it in terms of what we do not have that are being provided by the Constitution or by the special laws. We remedied it through the MOU. We work closely with the national government to make sure that we get a piece of what we need to do. So lobbying also plays a vital role. With regard to what Georgie mentioned about, there are also experiences where subnational government plays a critical role in terms of international recognition. And if some of you have been following the experience of Bangsamoro Autonomous Government, there was a time also that they also given an observer status with the Organization of Islamic Conference. So following the general statement earlier by Cheryl, she made mention that there is a need to maximize resources of what we're having in terms of the constitutional guarantee, in terms of domestic governance. And these things are relevant how to get, especially for those who are responsible in managing or exercise power over subnational government, it is important to get where we wanted to go and achieve a little bit of what we wanted to achieve in terms of the critical role that are being provided to us. And during my term working in the cabinet of the Bangsamoro Autonomous Government, we do participate in the international meetings to make sure that our agenda are being set forth in the national conversations. So that also, in a way, give up a leeway to us to make sure that we are being participative in the treaties and agreements that our country signed. Thank you, Amanda.
Thank you, Elaine. Miriam, did you have a comment as well? Miriam, I think your hand is up, but you're on mute. I'm not sure if that was intentional. All right. Not sure. In the meantime,
my hand, that was a mistake. I'm sorry, Amanda. My hand went up by mistake. But I just wanted to say that I share in with Dependents' frustration about how to decouple oneself from the constitutional provision. Like, for example, in their constitution, they said he said that Article 234 envisioned cooperative federalism and made provision for interprovincial cooperation. Whereas in our constitution, we have an express chapter for decentralization, and so much powers are given, but somehow it's not being activated or animated. I don't think there's any one country on earth that actually wants to cede the foreign policy making power or treaty making power to a lesser level of government. But I think we have to find some way as to how to decouple ourselves, to divorce ourselves. So divorces are not happy, never happy occasions, but somehow if the people want to have a better say, especially if it's enshrined in the Constitution, I think that must be given heed. Now, I take a lot of heart in how the public, members of the public actually organize themselves to oppose certain foreign interventions. Like, for example, an entire atoll of the Maldives was going to be sold over to foreign power, but somehow the public, members of the public got together and did a lot of demonstrations, and that thing went away. And a similar sort of thing is happening now as we speak with regards to the Indian cabinet, for example, announced without our cabinet not knowing about it, that they were going to have some sort of a presence in the southern part of the Maldives. But now the executive is coming very sheepishly saying that it's not a security related agreement, but it's a developmental agreement. So there is a lot of brouhaha going on, and I think I take hope. I was in a conference today with the Tom School of Politics, where an MP was talking about how in Australia there's a lot of although democracy is failing, people power is coming up, and she took hope in the fact that people can group together and call upon the federal government to give them that power to take part in international, the provisions, the rights given by international treaties. So I think we need to find out, maybe bring in Jonathan's binary, or what did he call it, typology, something like that, whereby small communities can actually exist collaboratively with the level up top and the level at the uppermost, where especially when the Constitution gives that right. So in short, I just wanted to say I share in with Defenders' frustrations there. Thank you.
Thank you, Miriam. I'm sure the solidarity is appreciated from Defenders as well. But I think it's a great way to end, also to think about the future. And I think this idea of the people's role in sort of asking for changes to constitutional structures or international affairs is something that we've looked at over the years in this forum. So it's very relevant even across other topics that we've looked at. I was also reflecting on how culture might come into this topic, which we discussed a few years ago, but how countries relate to aid, to foreign investment, and how they view things like climate change. So, quite a lot to unpack, but I'll leave that to our professional, Cheryl Saunders, who is excellent at distilling lessons and patterns from these diffuse discussions. So with that, I'll close the session 4 and we'll move to our final session, which we also do hope will be participatory. So any conclusions that you all have would be great to also hear them, or things that struck you as particularly interesting. As you know, we develop our constitutional insights after the forum and try to pick up on some of those themes. So always good to hear from you about what you'd like to learn more about or see captured in those. Cheryl, I think with that, thank you to the panelists and to all the participants for your excellent questions as well.
Well, I think Alina is going to speak for me, that's all.
Sure. Yeah. Well, thank you, Amanda. Thank you, everyone. And indeed, if welcome any thoughts and conclusions from the participants as well. And what I have to say is really a kind of a random set of thoughts, and I trusting Cheryl is able to bring together all these various threads from the conversations we've had. But what I felt we had discovered were numerous tensions. Number one being the local ownership versus international recognition we discussed on Tuesday. International recognition and whether and how much it mattered, depending obviously on the historical contexts, colonial histories, and so on, and how such recognition, while often required, did not necessarily correlate with durability or legitimacy of the Constitution for that matter. So after the first session, I was thinking exactly that, from where the legitimacy is stemming from, and particularly perhaps in the contexts where the constitutional order has collapsed. Aderito made a reference to the constitution declared by the freedom fighters already in 1974 in Timor, which did not receive recognition. And in Afghanistan, those who are for democracy are probably defending the current constitution, which well may be replaced by Taliban, given that what Samshad shared, that each ruler has marked their victory with new constitution in past. And James talked about Bougainville Constitution drawing its legitimacy from the peace process itself. And there are, of course, other constitutions in making in exile, sometimes also supported by external actors, like is the case of Myanmar. And the very question of legitimacy is at the heart of those debates, both in terms of local ownership as well as international recognition. And as a representative of an organization that is promoting democracy, I was also struck by what Akiko wrote about Japan's constitution, which content-wise can be said is very good and continues to enjoy popularity, but which basically, as we know, was written by an external power without much of a consultations. And she's kind of suggesting that perhaps something about how that constitution came about is to do with the weak belief in and apathy about democracy in Japan. And this in spite of this extensive civic education about the content of the constitution. So some interesting collective psychology at play, perhaps there. And we also discussed about what is meant by international recognition, or whose recognition opinion is more important than others, and who may be influencing the content and the process of constitution making, be it former or current colonial power, or the so-called Western world, or including the advisors, donors, all others involved, dominant power or occupying force, or emerging regional power for that matter. And more involvement of non-state actors as well, be it, for example, the international Islamic community or perhaps at times, indeed, international investors or the private actors who are looking for stability and predictable environment to invest in. So a myriad of factors. Under the treaty making, we discussed the second tension of accountability versus efficiency, recognizing the sort of newer trend on promoting parliamentary involvement in treaty making and status of international law in domestic law. And we had this interesting discussion about the silent incorporation of international treaties, actioning those treaty principles, even if not formally ratifying. And Singapore was mentioned as a country that only signs when it's meaning to action the treaty fully, then versus perhaps the window dressing of signing, but not matched with equally enthusiastic implementation. And there, I have to say, a country came to mind that I know somewhat, where the ILO 169 about the prior and informed consent by the indigenous peoples on matters concerning them was signed in 1989 as the second country in whole Asia, but of which non-implementation became an issue only around 2010 or so, when as it was discovered by the groups themselves that my country has actually signed such a treaty once upon a time. And indeed, today we had the third session about international investments, bringing about this whole gamut of issues on sovereignty, transparency, confidentiality, rights, public interests, constitutional safeguards, and even perhaps the very purpose of the Constitution itself, alongside with the geopolitical, geoeconomic significance of the Indian Ocean region and that of the Pacific, and which is only likely to increase as the race for Asia, as one of you wrote, is intensifying. And at the end of our second session, Tom put forward the question of whether climate crisis is a game changer here, as it cuts across so many issues and interests, and where sub-state and supra-state actors are only to become more important. And this came through in our last session as well. Perhaps one more point. I took a note again, as someone working for democracy, I took a note of what Benny Bagani said yesterday, on Tuesday, about democracies withdrawing from the treaties. And he gave an example of President of the Philippines declaring his country's withdrawal from the ICC. And of course, we recall President Trump and US withdrawing from the Paris Agreement, and President Biden rejoining or canceling the departure. I'm not quite sure, but who knows again what the next president will do, and do we have any, again, democratic guardrails here to rely on. So these were just a very random selection of my thoughts. So before I hand over to Cheryl, I just want to thank you all on behalf of International IDEA. It's been truly fantastic forum yet again. Thank you particularly to all our panelists, chairs of the panels, for sharing your knowledge and your insights with us. And thank you to our alumni and all the participants from around the world for the very helpful comments and questions. And I hope you enjoyed these discussions. And I also want to thank Constitution Transformation Network team and Cheryl for your leadership and wisdom, and everyone really working at the CTN, working behind the screens, and everyone who has been helping with the communication communicating about the forum through Twitter and all the other platforms that there is. That was much appreciated. And thank you all, and hope to see you soon again.
Thanks so much, Lena. Well, let me just add my my thanks to all of that. You know, this has been the most exciting and productive Melbourne forum. speaking for myself, but I'm sure I can speak on behalf of my colleagues as well. So thank you so much to all the participants, certainly the presenters, but everybody else who's participated in the discussion, for throwing yourselves into this rather new set of constitutional issues with such enthusiasm. It's been just terrific to be part of it. We'll be thinking very hard about how to capture and disseminate all these insights. Charmaine wanted me to tell you that the videos will be up soon, and we'll send you an email when that's so. As Lena said at the beginning of the session on Tuesday, we also produce a set of constitutional insights, short 8-page briefs from the sessions of the Melbourne Forum. And there's always an open question about what those insights might actually deal with. Perhaps in a rather unimaginative way, we tend to line up the insights with each of the sessions of the forum. I guess you would hope that that would be a logical thing to do, and it generally works. But we'd be very interested in any views that anybody has now as to how you'd like us to package these insights. I mean, would you welcome seeing coming out of this forum an insight on sort of treaty making and the domestic effect of international law, one on international investment with all of its complications, drawing on our international investment experts, and one on subnational involvement in international affairs. Perhaps also one on that first session, which was a wonderful session, on the sort of the roles of international approval, in particular high-profile constitution-making circumstances and the ways of achieving local ownership. Can we just throw it open briefly? Does that sound like a sensible breakdown, or would you be interested in seeing briefs on other topics produced from the discussions that we've had over these 2 days? All too late in the day to think about these heady questions, I'm sure. Look, it's not mandatory.
I guess, well,
I
mean, I shouldn't be commenting, but because I'll be involved in later discussions on this, but I think one thing that was interesting that we didn't really get to discuss that much, but was this idea of, I think, sort of party politics, and especially for subnational governments, you know, if they're being ruled or governed by the same party that's at the central level, how that kind of impacts the feeling of influence. And I think this came up, you know, last year with Pakistan in terms of COVID response, and I think it also came up quite a bit today. So I don't think it's unique to the subnational, but how do they, like, party politics influence these discussions and sort of influence the constitutional design, right? So you could have very clear separation of powers or oversight or symmetry, but in the end of the day, like how party politics might override some of that. So.
Yeah, well, you're right, it didn't come up particularly in this series of talks, although indirectly it did. But I do think it's actually a good topic for a brief generally, having recently had some discussions with an Ethiopian colleague and understanding the dynamics of party politics there and the difference it's made. That would be a really good thing to pursue at some stage.
Also, Dipender is not here, but it did come up with Nepal, the idea of the Lumbini province being like more affiliated with the central government and having an easier time of.
I know, it's sort of outrageous, huh? Okay, thank you. Anyone else? Well, look, this is not your last chance to influence these decisions. We will be thinking about it over the next few weeks, but if anybody has any thoughts after reflecting on the forum, we'd be really interested to hear them. And for that matter, any other thoughts that you have about where we might take these issues, because I'm sure we will be interested to keep thinking about them. Now, despite all the claims that both Amanda and Lena made on my behalf, I'm not going to attempt to summarize even the main ideas from the last few days, which are extremely complex and deserve very careful reflection. But let me just say something very briefly, and no doubt rather obviously. So the external face of constitutions has always been important. There's a lot of literature saying you need to be aware that constitutions do not only reflect internally, but they also reflect outside. Sometimes they're speaking to an international audience. Sometimes they are authorizing action in the outside world. And we've explored 4 facets of the external face of constitutions today, but others have emerged, and some of the facets we've explored could also be broken down. For example, the interesting discussion we ended with on the way in which international aid works, and for that matter, the way in which NGOs work. Even though the external face of constitutions has always been important, typically they say relatively little about dealing with the outside world. Sometimes some constitutions simply make assumptions about how the external face is going to operate, usually by leaving those matters entirely to the executive. But even when you have a constitution that empowers the executive and assumes that the executive is going to conduct most of the international action, that's nevertheless still in part a constitutional framework. And in some ways, the relevance of that is just beginning to really evolve. We saw it in the Sri Lankan paper, for example, where you find courts responding to public interest litigation, engaging with a whole lot of disputes involving external decision-making of one kind or another, as courts become a bit more emboldened to deal with executive action. Furthermore, as we've seen, despite the fact that my claim is that very often constitutions don't say much about external dealings and their external face, sometimes they do provide a more specific framework for aspects of external dealings than we might at first glance see. And we've talked about that in the earlier session today, the various categories that we might use to think about the external face of constitutions. Sometimes treaty making, sometimes the status of international law, sometimes protecting national sovereignty, etc. Sometimes, as in Sri Lanka and Singapore, those apparently accidental references to external affairs in the constitutions are the result of or the product of a particular historical moment. And sometimes that moment was a very long time ago, at the time the constitution came into effect to support an independent state. Sometimes the references to external affairs are more recent. But the cases of Sri Lanka and Singapore, for example, the external references go back quite a long way. And I think there are some potentially interesting subjects for research about what those mentions of external affairs in constitutions tell us about the evolution of the world and the international state system, for that matter. There is a question in my mind whether there's an increasing tendency for new constitutions to elaborate the external face of the constitution. Anecdotally, I think that new constitutions are more likely to provide that international law takes direct effect, although it's not entirely obvious that that is necessarily what happens in practice. But even where a constitution says relatively little about the external affairs, the effect of democratization may be to gradually expand the way in which the public sector deals with international relations, either through ordinary legislation or practice. And we talked about a few examples of that in all of the sessions. Now, we're exploring these issues in an age of extreme globalization and an age that's also facing extreme global problems. So much of what is done by democratically elected governments, in fact, requires external dealings. And the outcomes of those external dealings often have a profound domestic impact, more profound than many purely internal domestic policies. And so one of the many underlying questions for this forum has been, should democratic practice in terms of, for example, consultation and transparency play more of a role in this context as well? Democratic practice might seek to influence or control the stance that representatives take on the international stage, for example, in relation to climate change. And democratic practice might also seek to provide a framework for international commitments that have a direct impact on domestic well-being, for example, authorising mining activities with serious environmental implications. So there are all sorts of ways in which we might see pressure building up for democratic practice to have more of an influence on the way in which the external face of constitutions operate. And if that's so, the second underlying question for this forum has been, if democratisation is appropriate or desirable, can and should constitutions provide support for it, and if so, how? Those, I think, are the two sort of key questions we've been playing with in so many different contexts over the last few days. And we've been aware, as we've been doing so, that there are all sorts of cross-cutting issues here, some of them being cross-cutting questions about where geopolitics are taking us, and also where global problems are taking us as the world faces the potentially existential issue of climate change. Now, this forum, of course, has not definitively provided the answers to any of these things, but it has served brilliantly to open up the questions. And that, I hope, is a legacy it will leave us all. And we in Contransnet and in IDEA could not be more grateful to all of those who've supported us in doing this. And we look forward to continuing to work with you on these issues in the future. So let me just close by giving thanks to very many people, and Lena's already touched on this in her remarks. First and foremost, of course, thanks to our presenters who put together their wonderful answers to the questions that we sent them, and then thought so hard about how to present their ideas in such a short compass of 5 minutes, and then so generously answered the questions and engaged in the discussion. But thanks also to everyone else who's joined us online, from the Melbourne Forum alumni and the wider audience. You know, we've talked about all the Melbourne Forum alumni for some time now, but they have been such a support in putting this program together, coming up with ideas about people we might present, we might approach to present, and then attending themselves and engaging in the discussion. So we're very grateful to you all and to all of those who've joined us for the first time. And thank everybody who's participated for all their comments and questions. Many thanks also to those who've played such an important role behind the scenes, or as Lena put it, behind the screens. Most obviously to our wonderful Contransnet colleague, Charmaine Rodriguez, without whose energy and commitment none of this would have been possible. Charmaine has worked indefatigably for the past few weeks at least to get all the questions and answers together, to get the equipment together. And we are, as always, very grateful to you, Charmaine. Many thanks also to Fiona Ryan, who by very happy chance is both taking the Melbourne Law Masters at the moment and has been interning with International IDEA and has also provided us with invaluable backup. And to the Melbourne Law School support team, led by Angela Headley-Boys, who've managed all the technological and many of the communications aspects of the forum. We're really very grateful to you all. And finally, thanks to our colleagues in International IDEA, Lena Rakila Tamang and Amanda Katz-Barrell, and their underlying support teams as well. As always, it's been terrific working with you, and we look forward to discussing next steps as soon as we can draw breath. And while I'm at it, let me also thank my wonderful Contransnet collaborators who've played such a stellar role in the forum since it became a twinkle in our eyes. And I refer in particular to Anna Jedjits, Tom Daly and Dinesha Samararatne, who've been so fabulous in presenting ideas at the forum and in steering us through these really important questions. So thanks everybody, lovely to see you. We'll miss you tomorrow and we look forward to being in contact about these issues very soon.